Settlor intent is sometimes referred to as the pole star of trust law. After all, in principle, the maker of a trust should have the last word about who will be beneficiaries of their trust and what exactly they'll inherit. On the other hand, settlor intent is not an absolute. Anyone can make wild or outrageous requests in their will, but that doesn't mean they'll be fulfilled. A settlor's final wishes must correspond to the law, and that, of course, includes California trust law. Limitations on settlor intent have long applied, and among them, prohibitions against illegal acts, capricious purposes, and acts against public policy. Some scholars have opined that the maker of a trust, a settlor, could burn his own Rembrandt, but he can't convey a Rembrandt to a trust and direct the trustee to destroy it. Evolving court-made and statutory rules are trending toward the relaxation of rules for modifying trust. There are some good reasons for this, and they include trust terms are getting longer. Trusts are now fully enmeshed as part of a middle class estate planning and are no longer the province of only the rich. Trust often lasts for the lifetime of the beneficiaries. Estate and income tax laws regularly change and impact the administration and purposes of trust. And then clients often don't read trust instruments, and trust can often reflect the draftsman's intent more than the settlor's original intent. The last 2 points bring several cases to mind that we've seen up close over the last several years. And let's start with clients often don't read trust instruments. We've had cases where the trust maker couldn't speak or read English, yet signed a trust written in English. We've had cases where the trust maker was illiterate and the drafting attorney was oblivious to the fact. Of course, deathbed trust change cases nearly always raise the question of whether the deathbed trust or trust amendments were ever read. And how about the trust is more about the drafter's intent than the settlor's intent? Long documents with weird provisions abound. Most individuals or couples visiting an estate planner lawyer have relatively simple desires. Take care of each other while alive and children or grandchildren after they're gone. Single-space cookie-cutter trust with provisions completely irrelevant to the trust maker's circumstances are common. They don't make the trust invalid, but the provisions raise the question whether the draftsman of the trust was really listening. Trust mills are notorious for this, sometimes with trusts spanning 100 pages for an individual with a house that he'd like to leave the house in trust for a child or children. In any event, what should count is what the settlor wants. And granted, this is not always easy to determine, but it helps when the draftsman pays attention to what is really being said. Hackard Law represents abused beneficiaries in significant cases where we think that we can make a substantial difference and there is a wrongdoer who can be made financially accountable for their wrongdoing. We focus our geographic practice in California's largest urban areas, including Orange and Los Angeles, Santa Clara, San Mateo, Alameda, and Sacramento counties. If you believe that you are an abused trust beneficiary in a California trust and you want to talk to us about it, call us at Hackard Law, 916-313-3030. Thank you.